I think I covered assumes facts not an issue. And let's see, if I go on down here, privileged communication, cross-examine beyond the scope of direct. Yeah, it was on this cross-examination. Cross-examination is another thing that the lay witness is just, or the layman who is the defendant just really falls down on. We've noticed time after time where they try to ask questions that have not been asked and answered. So remember this rule on cross-examination as an example. You can only cross-examine on those particular issues that have already been asked by the prosecutor, and vice versa. Let's suppose that you're asking some questions along the line of, well, Officer Smedley, did you observe Defendant Gordon driving down Chinnen Boulevard? Yes, I did. And what did you observe? Well, I observed that he was driving a red 1965 Chevrolet automobile. And did you notice anything unique about the automobile? Yes, it had mud and snow tires on. And how fast was it traveling? 80 miles an hour. And was this in excess of the speed limit? Yes, it was. Your witness, counsel. All right, so now I begin to cross-examine. Now, Officer Smedley, isn't it a fact that you don't like me? Objection, Your Honor. It's irrelevant. Oh. Well, Officer Smedley, isn't it a fact that you saw me driving down Chinnen Boulevard and that the car was really green and not red and that I was driving at 40 and that you just did this to me because you were mad and you didn't like me and on top of that you had a fight with the wife and you kicked the dog? Objection, Your Honor, that's irrelevant. No foundation. Now do you see what I'm doing here? Now let's start getting to the nitty-gritty. Now, Officer Smedley, where were you situated when you made these observations? I was at the corner of 35th and Chinden. And what did you observe? Well, I observed a red 1965 Chevrolet automobile driving at a high rate of speed down Chinden. And what was it that brought your attention to this automobile? Its high rate of speed. Why did you think it was a high rate of speed? Well, my radar gun trained on the vehicle indicated 80 miles an hour. And your training indicated what? That it was traveling at a high rate of speed, 70 or 80 miles an hour. And then what did you do? Then I gave chase. And when you gave chase, did the automobile attempt to evade or to escape? No. Did the automobile pull over? Yes, it did. Was there an ambulance right behind the automobile? Yes, there was. And was the automobile driving at a high rate of speed in order to get out of its way so that it could pull over in a parking lot? I don't know. Now, do you see, I'm going beyond the scope of direct examination. The prosecutor only asked about 4 questions. And I can only cross-examine on that subject matter. I can ask all kinds of questions about the color of the car because the prosecutor asked the question, what color was it? Well, it was red. Well, was it red or was it red? Well, it was red. Was it maroon red? Well, yeah, it was maroon. What kind of paint was it, acrylic or enamel? Well, I don't know. Was it waxed nicely or was it dull? So you can ask all kinds of questions about the color, the paint, and everything else because that was asked on direct. But the ambulance, there was no subject matter of ambulance brought up. And so if you can get that in, that's wonderful. But if you don't get it in, don't get emotional about it and say to yourself, well, I can't ask any questions. I don't know how many times I hear this from citizens. Well, they never let me get my story in. They never let me tell my side of things. And, well, they just are against me. Well, I'm sorry, friend, but they're not just really against you. The truth is they may be, but you've got to play by these rules. And if you don't play by these rules, then you're not playing by your constitutional protections because all of these objections, whether the prosecutor makes objections to your questions or vice versa, are designed to protect the constitutional due process of the courtroom. And in addition to that, it's got to be played by some kind of rules. And the problem that I see with lay people in the courtroom and the judges and the lawyers see is that they want the lawyers and the judges to play by the rules as they're laid down, which are here. But the layman who goes in to argue the traffic ticket he doesn't want to be held to these same rules, to these same standards. He wants to say, well, gee, I'm just a factory worker. Well, you can't expect me to ask these questions properly. Well, I don't know if that's good or bad or right or wrong. I'm just telling you that that's the way it is. And so I think the best way to solve that problem is simply learn the rules, and they're not that difficult to learn. Now, self-incrimination comes under the Fifth Amendment. You cannot be compelled to incriminate yourself either at a motion hearing, arraignment, or anywhere else. Now, I've observed with my own eyeballs judges try to compel people on these IRS audits to make certain incriminating statements. And if you'll take a look at legal quotations, you'll find that legal quotations has a number of Fifth Amendment issues and legal quotations. You can only be put on the witness stand of and by yourself. You have to do it. They can't. So if it's a criminal matter and you take the witness stand and you testify, they can only ask questions based upon the foundation. So what you do is you write out the questions that you want to ask and answer yourself. Mr. Gordon, where were you on April the 10th, 1983? Driving down Chinden Boulevard. How fast were you traveling? 35 miles an hour. What color car were you driving? A green 1965 Chevrolet. You ask yourself the question, you answer the question, and then when the prosecutor asks you a question and says, isn't it a fact that you were traveling in a red Chevrolet at 90 miles an hour? No foundation for that. Oh, yes, there was too, excuse me. You said you were traveling at 35. And then you can say, no, I was traveling at 35. Isn't it a fact you've been arrested 10 times? That, no foundation, it's irrelevant and immaterial. I mean, there's 5 objections to asking a question like that. And if your questions are written down and you answer the questions that you want into testimony, that's all the record is ever going to show. And you cannot cross or be held for self-incrimination if they try to ask you a question. Were you traveling at 80 miles an hour? No. Did you have marijuana in the trunk of your car? Objection, Your Honor. There's no foundation for that question. Because, you see, there's no testimony as to what was in the trunk of the car. All right. A conclusion of a non-expert. The only people that can make conclusions now are experts. And so the fellow has to be qualified as an expert pursuant to the rules. Take a look at the rules of procedure for qualifying an expert witness. And if they fail to qualify the expert witness, then he's a lay witness, and a lay witness cannot make a conclusion or an opinion. The answer is not responsive to the question. You may want to object to an adverse witness who is evasive. When you ask the question, where do you work? Who told you I work? There's an answer that is not responsive to the question. Your Honor, will you direct that the witness answer the questions that are put to him? And he can answer yes, no, I don't know, or he can be evasive. If he's being evasive, everyone can see it, but you've got to make the objection that the answer is not responsive to the question. Otherwise, the judge will just sit there and say, well, you dummy, if you knew how to object, I'd probably order him to answer some of those questions. The exhibit or the phone conversation is not authenticated. Now, the exhibit, as it is being put into testimony, remember, we covered that one. It's got to be authenticated. But in addition to that, what do you do about a phone conversation? If the phone conversation has been tape recorded, was it tape recorded pursuant to a Fourth Amendment warrant? Because if it wasn't, then it's not authenticated. Is the phone conversation being testified to by 2 witnesses or more? Is the phone conversation in some other way that's been taped? Is it the result of taping and dubbing, and so the conversation is lifting words out of 10 conversations to make one conversation that's incriminating? I mean, that thing has got to be authenticated. It's difficult to get that kind of evidence in. All you have to do is this exhibit or this phone conversation is not authenticated. I'll bet you that fully half or more of the prosecutions brought against citizens are as phony as a Federal Reserve note. I saw a fellow that was charged with making obscene phone calls to someone. The only person who could testify as to the obscene phone call would be the victim. And they didn't have any tapes, and they brought charges against this guy, and I don't remember if he was convicted or not. But can you imagine what he would do with that one witness? All he's got to do is create a contested issue of fact. I never made any phone calls on that day. There's the contested issue of fact. And she goes to testify. Well, what did you hear? Well, I heard these words. And she could testify to those words. And who was it? Objection, Your Honor. That's hearsay. She can't testify as to what you said unless there's an exception to the hearsay rule that's brought up. Only you can testify, and you may not want to take the stand. Well, what did this person say, whoever it was that said it? Well, it said thus and such and so and so. Okay. Who did, they may ask, well, who did you think made that call? Objection. This calls for a conclusion of the witness. It's I think the defendant made it. And if they say, well, who do you know made it? I know George Gordon made that call. Now there's a direct statement. How do you know? Well, I recognized his voice. Okay? All right. Let's see what else we've got here. The expert is not qualified. Remember this, that expert witnesses have to be qualified, and a lot of foundation has to be laid. I think I went through that with the Diamond Man on another objection. If the guy is 25 years in the business and he's been an expert witness before and he can testify to all those things, he'll probably qualify as an expert witness. Why don't you check the rules in your state to find out what expert witnesses testify to? And while you don't necessarily have to memorize them, it'll jog your memory when you're in the courtroom and they bring in this so-called expert witness and they ask him 5 questions when maybe there's 15 or 20 things that have to be established. You'll be amazed at how lax the prosecution is in presenting its case. They'll present about 10% of it, and that's why you need this book and this lesson 26, and we're going to send this to you so that you can sit down and say, okay, I'm going to prepare my case 100%. The expert is not needed on this issue. You don't need an expert witness to testify as to something that he saw. You don't need a doctor to testify that that was blood coming out of the guy's arm as it drips on the ground from an auto accident. Everybody can see that what comes out of there is blood. So an expert is not needed. I object, Your Honor. An expert is not needed on this issue. And an expert has not testified to the facts observed. Now, there are some facts. Now, let's see if we can come up with an illustration or two that would have to be observed by an expert. A doctor would be an expert who is going to testify to certain facts, and if this was a malpractice lawsuit or something on that order, and this doctor is testifying, and he's being asked for a conclusion. Let's say, well, do you think then, doctor, based upon your years of experience, that Mr. Jones was pushed off the balcony or that he fell off of the balcony? Objection, Your Honor. The expert has not testified to any facts that he knows whether this person was pushed or shoved or whether he fell accidentally. Now, that could be relevant because a person pushed off backwards might maybe fall in a certain way and break his back. A person who jumped might fall in such a way that he landed on his legs and he would have broken legs. In any event, there would have to be foundation laid by this expert. This expert would have to see who was pushed off the balcony or who jumped off the balcony. Now we get into some hypothetical objections, and that is a hypothetical, I object, Your Honor, because this question is hypothetical because it omits material facts and evidence. Okay, material facts that are in evidence when you're asking for a conclusion, then based upon your experience, a policeman may testify, would the car skid 150 feet on this wet surface or only 100 feet? And it would be hypothetical because there's no testimony or evidence that the car slid so much as 1 foot. So foundation would have to be laid to show that the car slid. There would have to be foundation and testimony or evidence that the pavement was wet, and that this officer was an expert in automobile sliding on wet and dry pavement before you could ask some kind of a question, then in your opinion, did the car slide 100 or 150 feet? Or would it or could it? The next one is hypothetical because it unfairly selects only part of the facts proved. Now, if the facts are proved that the pavement was dry, and a hypothetical question comes up asking the officer for his expert opinion, well then, on wet pavement, the car would slide at least 150 to 200 feet. Now, isn't that a fact, officer? Yes. And here the testimony shows that the pavement is dry, and so this hypothetically trying to show that if the pavement was wet, the car would slide 200 feet, but the evidence shows that the pavement wasn't wet, or it doesn't show if it was wet or dry, then it unfairly selects only part of the facts proved. A fact proved, the car slid. A fact proved, there was an accident. A fact proved, the pavement was dry. Part of the facts unproved is that the pavement was wet and that the car would slide 200 feet if the pavement was wet. And they might ask a question like that to show that since the car slid 200 feet, the pavement was wet or dry, or that there was excessive speed involved. So you want to keep that in mind. And then, of course, it's up to you to figure out how it applies in the particular case you're doing. Hypothetical. It contains facts that are not in evidence. So anytime that the answer to a question would bring up a fact that isn't in evidence, and it's hypothetical being, well, could it have been? In your opinion? Do you think that? What do you believe? Those are questions that are hypothetical. What do you believe? Or what did he believe? Well, I don't know what he believed because I don't know what was in his mind. Or I object, Your Honor, because he doesn't know what was in his mind. Well, what did you believe at the time? What was in your mind? Remember that what's in people's minds is important because it goes to the second element of crime, which is intent that goes along with the act. Now, we've covered 27 of what I call here of the more common objections. Now, I'm going to send these to you in writing, and I've said that 2 or 3 times, and it'll be up to you to go through these and to practice on one another. Why don't you sit there with a friend and ask some questions and see whether or not those questions can be asked or whether or not he can object to that type of a question. If you were to become proficient at all 27 of these, beginning with the pretrial rulings, or an objection to moving forward, before the preliminary matters have been taken up, and hearsay, leading and suggestive question, asked and answered, cumulative, improper, expert not qualified, irrelevant and immaterial, and we can go on and on. Do you see the potent weapon that now you have? You're a factory worker, wherever you are, and you're going into court and you're going up against a law student who hasn't prepared his case very well, and all of a sudden you go in armed with a book, and you've got your jury instructions, and you've got your jury questions, your voir dire, you've got your all of your motions are in order, and you've got your theory of the case laid out. You've got their case laid out. Now let's talk to you a little bit about how to lay out the prosecutor's case. As I've said before, there's just no substitute for preparation. And I like to prepare, because I do this not only for fun, I now do it for a living. I'm trying to teach other people how to do it also. Now, remember the Edison and the Ford principles. This thing of vanity, I talk to so many patriots, that don't want to listen to anybody. They've been in court 3 or 4 times themselves, and they just don't, what they don't know isn't worth knowing. And with all due respect to you out there, I disagree. I've been doing this for a long time, 5 years, And I don't think that a day goes by that we don't learn something. You know, we'll learn something on procedure. We got laid away the other day on a very minor technical rule in filing a writ of habeas corpus that was buried in an obscure statute. And our writ of habeas corpus was denied. And we've written probably a dozen writs of habeas corpus in the last year for students and other people that needed them. And here the court laid us away on this technical rule. Well, they won't do that to me again, because you see, we've documented that one. But this thing of preparing your case goes to two elements. One, there's really two cases that you need to prepare. One, you're going to prepare your own case for defense, but you're also going to prepare the prosecutor's case for prosecution. And in order to do that, you sit down and you say, okay, if I was the prosecutor prosecuting this case, here's what I would do. So you open it up and you say, okay, number one, I need a complaint. And so you take a look at the complaint, and in the complaint, remember, in pleading the complaint we learned, you take that thing apart, every single word of it, and check it out, and you make absolutely certain of the elements of the case that you have to prove as the prosecutor, and you write them down. One of the elements was the intent. One of them was the act. How am I going to prove the act of tearing up the jail suit? Well, I've got the physical pile of rags over here, 11 pieces of rag. All right. I know that there's 15 pieces of rag. How am I going to explain the missing 4 pieces? Okay? Here's the way I'll explain them. He could have flushed them down the toilet. That's why 4 of them are missing. In other words, if I'm the prosecutor, I've got to come up with something that's logical. Because could they have been burned? Yes. The prisoners all have matches, and he could have burned those in an ashtray, a piece at a time. Oh, okay. So you put down those theories in the event that the defendant raises the question of, well, what happened to the missing 4 pieces of the jail suit? And so you take the complaint. Does the complaint lay out every element that I have to prove? Does it show the crime was committed in Ada County? Yes, it does. Does it show that the defendant committed the crime? Yes, it makes that allegation. And you lay this thing out on the complaint. Now you start over here. How's the prosecutor's opening statement? The prosecutor is simply going to allege that he is going to be able to show you through his witnesses and evidence all of these material facts and allegations laid out in the complaint. And that's called his prima facie case, of which there may be 6, 8, 10, or 12 items. And you list all of those. Next, witnesses. How many witnesses is the plaintiff, that is the state, the prosecutor, going to put forward? Officer Honey, Officer DeLeonard, Officer Smedley, and 1 prisoner. 4 witnesses. What are they going to testify to? They are going to testify to the fact that 1, they saw Gordon tear it up. 2, they came in 5 times and Gordon wasn't wearing his jail suit, and so on. This is everything that those witnesses are going to testify to. You write up here at the top, Honey, all the questions the plaintiff might possibly ask. Now you see, you're laying this out like you're going to put this guy in prison for the next 20 years. I'll show this guy he can't tear up government property and destroy and tear down jails. That's got to be your attitude. All right, now, your closing statement. If I was the prosecutor, what would I say? Based upon this evidence and testimony, ladies and gentlemen, you've seen the jail suit. You've seen the destruction wrought upon the government's property. Ladies and gentlemen, you've heard Officer Honey. You've heard Officer DeLeonard. You heard how the defendant obstructed and delayed, and you have heard how he did this and that and another thing. And you should bring back a guilty verdict and show this criminal that he can no longer flaunt the laws of civilized society. I mean, you know, you can sit here and just come up with a whale of a good case. If you actually do the case that, as you see it, is going to be done against you, and you have that in your mind, now you're in a pretty good position to defend against that, aren't you? So, as the defense, you turn over here and you say, well, now, what's the first thing I need as the defendant? I need a copy of the complaint. You see, I'm going to attack the intent. I'm going to see if they're going to prove intent. Who actually saw me tear up the jail suit? Who is this false witness that they're bringing against me, a convicted felon? You see, you can ask in Idaho one question. Sir, have you ever been convicted of a felony? Yes, I have. Now you've told the jury that the guy who is a witness against you is a convicted felon. What are the questions you'd want to ask Officer Honey and DeLeonard? What did they see? What did they hear? What did they do? I mean, after all, you're the defendant. You were right there in the cell. You know all of the events that came down. Write them out, one at a time. Officer Honey, which way were you facing? Even go so far as to draw a diagram of the jail cell. Where was the table? How big is the cell? You know, on discovery, you can get the actual dimensions of the cell and the layout of it as necessary and imperative to the defense. On discovery, you ask them for every material document in your, as an example, in your either civil or criminal rules, you'll find an example of a discovery motion. And you on discovery ask for every witness that they're going to produce. And all scientific tests, all evidence, physical, tangible and intangible evidence that they're going to produce. And you take all of that and then you fit that in to that jail cell, the bunks, and then for the jury you draw a diagram and show where the bunks were and how many feet it was over there. And Officer Honey was standing here, and you get Officer Honey on cross-examination. And always remember this, when the prosecutor brings in 3 witnesses, always subpoena the same 3 witnesses for yourself, whether you use them or not, because when your half of the case comes on, the state has already rested. And you can decide then if you want to bring Officer Honey in. There may be a reason why you want to leave him out. Don't bring him in. But if you don't have him subpoenaed, as soon as you finish cross-examination, the prosecutor can say, you're excused, Mr. Honey. And then if you find after the prosecution has rested its case, hey, I need that guy, it's too late. You failed to subpoena him in. So as a rule, on the defendant's half of the case, you see, you sit here and you subpoena all of their witnesses and all of their evidence because you want their evidence also for your defense. I want to show you, ladies and gentlemen of the jury, that these 11 rags here are missing all of the thread. What happened to the missing thread? I want to show you they don't even have a complete jail suit. Not only is it their evidence, it is your evidence. It's their evidence to show that the allegations that there was a destroyed jail suit, but it's also your defense evidence to show that it was necessary to use a special tool to do this, and that the fabric was never torn, that only the thread is missing, and that the thread in these jail suits. And then you'd bring in your whole jail suit with the tailor's testimony, and you'd bring in the special little cutter that is required, and you would begin to disassemble the suit, and then tell the jury to go back into the jury room for deliberations and try to unravel the thread. Try to cut the thread. See whether or not my witness is credible. See whether or not this professional tailor would take 4 hours and 22 minutes to physically disassemble this entire jail suit. Dot every I and cross every T. Because even when the jury comes back with the guilty verdict, that record is set in cement. Now when you go into the appeals process, you'll win that case. And let me say this, you will probably never win a case in front of the jury unless or until we can get educated citizens out there that know and understand jury nullification, jury lawlessness, grand juries, how grand juries function. Citizens are simply pawns in the hands of prosecutors. Read Hale versus Hinkle. See what the Supreme Court of the United States said about that. The Supreme Court of the United States recognizes that the prosecutors use grand juries like putty or like clay being turned at the hands of the potter. And the reason for that is that we don't have an educated citizenry that is in control of their government. Government bureaucrats are in control of the government. And it's government bureaucrats that decide who will and who will not be prosecuted. Is it any wonder then that Christ was prosecuted, selected out, and prosecuted, that Paul and Peter and John and James were all selected out and prosecuted? Where was the grand jury that they took Christ before? Where was that citizen, that body of citizens who would examine him? I mean, he was a very popular fellow. Everybody liked him. He had a great following. Don't you suppose that the grand jury would have been convened and said, well, what evil has this man done? He runs around healing people on the Sabbath. Well, so what? We like guys running around healing people on the Sabbath. And as far as we're concerned, you can heal him on Sunday or Wednesday or Thursday if you want to. If there'd have been a grand jury, there probably never would have been an indictment. But they brought him before government officials. They brought him before government prosecutors, and it was the government agents that did the entire prosecution. And that's exactly what we have in the United States of America. Now, I'll concede that there are some states that still have functioning grand juries, and the federal grand juries are still functioning. But let me tell you, the federal grand jury is not a grand jury of the citizenry and of the freemen. It is a grand jury that's molded and controlled by the prosecutors in almost every case. And we need to make some meaningful changes there. All right. Getting into the defendant's half of the case, here's jury selection. Remember, depending upon your particular case, not all of those 84 questions that you have in our jury selection lessons 21 and 22 are applicable. That's 84 questions that I asked in a particular case one time that had to do with constitutional ramifications. But when I use that list, I don't ask every one of those questions, and neither should you. And you may have another 84 questions that go along with those that you asked. There may be 150 questions that go to the qualifications of a jury. Jury instructions. You want to have all of your jury instructions right in here. Remember, those are key and crucial. That's the way you instruct the jury as to the constitutionality of the law. And then you use your jury instructions right here in the book to ask the policeman the right questions so that you've established those facts. And by establishing those facts, the policeman then has established Idaho Code 18201. Did you see the defendant do this? No, I didn't. Is there any reason why he would do this? I don't know. Did you pay him to do this? Is there any motivation for him to do this? No, I don't know. Then you get intent, 18201. Whatever jury instruction, whatever you want, whatever constitutional amendment you want to get before the jury. You want to get the Fourth Amendment before the jury? You've got to get factual testimony out of the officer. That's why at the scene of the crime, officer, I demand all of my rights, including a Fourth Amendment warrant. Fact. Did I demand a Fourth Amendment warrant? Yes, you did. Did you get a Fourth Amendment warrant? No, I did not. Why didn't you get a Fourth Amendment warrant? Well, because I didn't need one. Now, jury instruction, Fourth Amendment. And you just take your Fourth Amendment and you write out the Fourth Amendment. Jury instruction number 1, the Fourth Amendment to the Federal Constitution. The record will show that testimony has been admitted that the Fourth Amendment is an issue in the trial and that it's a constitutional issue and it's a matter of law and the jury has to know it. The judge says, no, I'm not going to let jury instruction number 1, the Fourth Amendment, get before the jury. Appealable issue number 1. Faulty jury instructions. Had the jury known the Fourth Amendment and that the officer did not have a right to look in my trunk, they would have found me not guilty. That's the way jury instructions are used. Any court orders that may have come up. Has the court made any orders that you may want to incorporate into your defense? The law. What does the law say about your defense? That's extremely important. Because the law may exonerate you. For instance, yes, I admit I did not go down and register as an alien. But the law is aimed only at aliens, not natural citizens. You take the witness stand. I'm a natural citizen born in Fortuna, California in 1939, July the 30th. I wasn't born in Greece. The government's accusing me of being born in Greece. That's not true. And then you get the law on the subject. I don't have to register because I'm not an alien, and they were unable to prove that I was born in Greece. And then, depending upon your particular state, maybe there are some other factors or elements pursuant to your rules that you'll want to prepare for. But let me tell you this. My experience has shown me that a truck driver who dropped out of school in the 10th grade, who cannot type, doesn't read or write well, can't write, has to print, is a poor candidate for going into court and arguing a court case before a jury.